Distinguished guests, ladies and gentlemen. Expected to have it in writing, and I will tell you that my students here, and I can speak of at least three, Honorable Winston Anderson, Chief Justice Rawlins, and Senator Velma Newton herself will tell you that when I was a lecturer at this faculty, I never lectured with notes. And so I will say to you that I will speak from the heart, or for our Spanish-speaking guests, yo voy a hablar desde la corazón. This for me is a very nostalgic experience. The very first lecture I ever did in my life in April of 1976 was in this room. And sitting around about where Justice Mason is sitting, Justices Mason and Crane Scott and the Chief Parliamentary Counsel is sitting, were then student Kay Goodrich, now Justice Kay Goodrich, then student Jennifer Edwards, now Solicitor General Jennifer Edwards, and a whole host of now senior practitioners. And I was terrified. I am a little less terrified today because I view with great happiness what is happening today. Yesterday I was treated to what can only be described as a treat. The Supreme Court complex hosted a hearing which took place before the Inter-American Court of Human Rights. And it was fascinating to me on a number of bases. It was essentially what we would call a family law issue. What was at stake was the right of a father who had been denied custody, of his child, the right to custody of that child. For 7 years of my life in New York, I worked in the matrimonial center of the Supreme Court, and I dealt with those issues every day. It was from child custody to child support to spousal support to division of marital assets. What was fascinating about yesterday's occurrence, however, was that I learned that even family law matters can have an international component, because the gravamen of the question before the court was the extent to which the state of Argentina had violated the rights of a parent to the custody of his child, and the assumption that that right to custody of his child was indeed a human right. Yesterday was what I regard as the first time for a momentous occurrence. It's the first time we actually got to see the International Court, the Inter-American Court of Human Rights in action. What today is all about is a discussion of the operation of the Inter-American system, and more importantly is that there's going to be a discussion of how it interacts with our system. Because one of the reactions that has become pretty much natural is to raise the question, does the operation or do the decisions of the Inter-American Court infringe our sovereignty? The problem is that we have a certain arrangement which exists in our domestic law, but which seems to run afoul of the decisions of the Inter-American Court. And so our reaction tends to be one of suspicion. Why are they making these decisions? I take the view that this is an opportunity for us to engage in what Professor Max Weber called reflective equilibrium, i.e., we discuss their ideas, they discuss ours, and ultimately we come to a state of reflective equilibrium where we are comfortable on each side. We will then get to the point where we do not see our system as under attack, but as remaining intact. And we will get to a point where we will see their decisions and ours as complementary and not contradictory. And right now, our reaction is to believe that there's a conflict between their decisions and ours. I believe that all that is required is for us to start looking at our own decisions and our own juridical arrangements. And I think that's the problem. The problem is that our juridical arrangements differ from the arrangements with which the judges of the Inter-American Court are accustomed. And we obviously have to make some amendments, or as they would say in America, you have to do a little bit of nipping and tucking until we reach a point where reflective equilibrium is arrived at. On a number of bases, I am glad to be here, not just for the nostalgia. We are going to pass on, whether we like it or not, our jurisdiction and our jobs and our responsibilities to younger minds, and the time at which we should engage them in the discussion about our relationship with the Inter-American system is now. We can't wait until we get to our, well, I'll say my age. I'm not going to get myself in loads of trouble by suggesting anybody else's age. But we can't wait until we get to my age then to be surprised by the fact that we're in fact part of a region, and that as part of a region, there's a necessity for us to be interdependent on other members of the region. And so the time for us to have that discussion with our younger minds or with our youth is now. Señor Presidente, I hope that this is but a first step. As they say in French, c'est la première pas qui coûte. It is the first step which counts. And I want to believe that this is but a first step in a long journey together. It is my hope that we will continue discussing our relationships, and believe me, after 7 years of working in a matrimonial court, I know that relationships have a way of evolving and not always for the better. And so let's treat this as a relationship where as we talk, we evolve and we deepen our friendship and our togetherness and the understanding that we are dependent on each other, and so that we are not losing our cherished institutions, but rather we are committing those cherished institutions to a more regional and international outlook. Once again, I want to welcome the Inter-American Court to our shores. We in Barbados like to believe that we are the most welcoming island in the Caribbean. We will obviously get dissent from other islands in the Caribbean. And even then, we will have to have a little international discussion as to who is the most welcoming. We are glad that you are here. We look forward to a fruitful discussion regarding the Inter-American system and a fruitful discussion regarding the death penalty, which in fact is the one main issue which seems to divide us. I want to believe that it really doesn't divide us. It is just a call for us to, as the Bible says, come let us reason together. It's an opportunity to reason together. And I am happy that the case that I witnessed yesterday was in fact a simple family law case, a case about custody, which in fact raises international issues. As I said, I know I am in the process committing a violation because somebody's going to come and ask me for a copy of my speech, and I'm going to have to see if I can photocopy it from my brain. But I want to express my gratitude to Senator Newton for inviting me to make these remarks, and I once again look forward to a very fruitful discussion, and I hope that we will go away understanding that there are more things that make us similar than make us different. And if we work on the similarities, the differences will become minimal, and ultimately, to use a legal term, de minimis, they'll become trivial and unimportant. I thank you all.
Before we proceed, I would like to acknowledge the presence of Madam Justices Crane Scott and Sandra Mason from the Barbados Supreme Court, and the Chief Parliamentary Counsel, Ms. Shirley Bell. There's a slight adjustment to your program, ladies and gentlemen. For this panel, which will be moderated by Judge Macaulay, and I will turn the session over to her immediately, I would like to add as number 6 on panel 1, Ms. Carolyn Gomes of Justice for Jamaica, I believe. Yes. So I will turn the proceedings over to Judge Macaulay. Thank you.
Good morning, everyone. I trust we're all awake. Yes? I'm ready to go. If you will permit me, can I take the courtesies as the Dean has done a very extensive job of it, and we're starting rather late. But there are a couple of people I would like to mention, and that's Mrs. Roberta Clark, the Executive Director of UN Women. I'm a women's rights advocate, so I must mention her. And may I mention Mr. Robert Queller, who is the Executive Director of the Interamerican Institute, where lots of students go to get acquainted with the system and the cases which are dealt with. It is in Costa Rica, in San Jose, and I hope some students from here will participate in the courses which the Institute holds. So if you will permit me, I will just make a very short statement that human rights is becoming even more of an imperative, the protection of the human rights of citizens. The world is in a state of serious economic decline. When that happens, lots of states forget about the human rights of its citizens. The world is also plagued with terrorism. Again, in those circumstances, lots of states do overlook the human rights of their citizens. Therefore, it is more of an imperative that we do everything, constantly, repeatedly, to protect the human rights of our citizens. And those of us who are interested in it must be on the lookout at all times and be courageous enough to move towards that protection. This is the reason why the Inter-American system was in fact conceived, to protect the human rights of the citizens of the region, the Americas as we're called. Big brother and little brother, the USA and Canada, of course, are members of the OAS, but they have not recognized the jurisdiction of the court. There was a judge from America, Judge Manuel Ventura is far more knowledgeable about the history of the court, who I think he was among the first set of judges who sat in the court. Since then, we haven't had a member from America nor from Canada. Indeed, they can be. But you will hear all about that later. I am not going to delay you further. As I said, we have started rather late. And we have a sixth member of the panel who's she's actually Dr. Caroline Gomes, and she's the executive director of Jamaicans for Justice. They are the largest and most active human rights organization in Jamaica who use the system, despite that members, Jamaica hasn't recognized the court. But she will tell you of how yet, or is in the process of moving towards recognition of the court, can use the system and use it effectively, as effectively without going to the court as it can someone. Well, the first person who I will call on to speak is Judge Alberto Perez, who is the member of the court from Uruguay. Judge Perez, I have to tell you that I am a moderator who was given no instructions about the biography of most of the people speaking today. They seem to take it that I must know everything about them by osmosis. So I'll do the best I can. Judge Perez is an attorney at law, is a professor of law. He was also an interpreter of the UN for many years. He speaks English very well and is forever telling me jokes because he sits next to me. He's full of fantastic jokes. He will speak on the organs of the Inter-American court system. And the court indeed is extremely lucky to have such a member of the court. He brings great knowledge and experience to the court. Please welcome Judge Perez.
So good for you. My very good and learned friend did not engage in my biographical sketch because I am the oldest member of the court right now. So it will be a long story. In fact, Judge Leonardo Franco, who unfortunately is not here because of health problems, is my senior by about 2 months. We are all, he's from April, I'm June. Anyway, let's try to say as many meaningful things as possible in a very short time. I'm supposed to talk about the organs of the Inter-American System for the Protection of Human Rights. Those organs are, as you already know, the Inter-American Commission for Human Rights and the Inter-American Court for Human Rights. Difference between them, the similarities between them, is what I will try to show here. I start by saying that these are two sister but not twin institutions. They are sisters. We are sisters, and we are both involved in the justice system for the human rights protection in the Americas. Like siblings usually do, the main thing between us is love. But sometimes, as it also happens with siblings, There is, I wouldn't say the opposite of love, I don't dare say the name here. What we might say is that there is competition. And since the structures are similar but somewhat different, the functions are parallel but sometimes concurrent or no overlap, not overlapping, then there is what we might call a competition, which is good for the protection of human rights. It leads to a more perfect protection of human rights. They are not twins, as I said, because they were not born at the same time. The Commission, at least in its initial form, was born in 1959-1960, created by a resolution of 1959 and installed, if I recall correctly, in 1960. A decision of a meeting of consultation of foreign ministers of the OAS. The court was created by a treaty, by the American Convention on Human Rights, dated 1969, but the convention itself entered into force in 1978, and the court was installed in 1979. Consequently, we are younger than the Commission by 20 years, which is a difference, although the Commission underwent several changes. This should lead us just to make a very short mention of the different instruments for the protection of human rights in the world and in different regions of the world. The international protection of human rights is something that did not exist before World War II. It was a consequence of the egregious violations of human rights committed by the Nazi regime that the world understood that something had to be done in order to protect human rights, even, or particularly rather than even, against action by the government of our own countries, sometimes to prevent, sometimes to correct minor injuries, we would say, but sometimes to correct very big injustices. The Inter-American system was in a way a forerunner of the universal protection of human rights. Even before the UN Charter was signed and entered into force in 1945, in early 1945, a few months before those dates, in a conference held in Chapultepec, Mexico, there was what appeared to be a huge momentum that would lead to the establishment of a very well-developed, full-fledged system for the protection of human rights. However, when 3 years later, in 1948, the Organization of American States was formally created as a continuation of the pre-existing Inter-American system by the Charter of Bogota, we could say that maybe the word of order at that day was not so fast, not so fast. Instead of having a binding convention with duties for the states and rights for the people and organs established to protect those human rights, we only had a declaration. Now we say only, but it was a great innovation at the time. It predated the Universal Declaration of Human Rights by several months. It was a source of inspiration for many articles of the Universal Declaration, and it has, ladies who are here present, a big problem of language. It is the Declaration of the Rights and Duties of Men, not of human rights. That would be corrected in the Universal Declaration, which in English from the beginning was called of Human Rights. In Spanish, you had to wait for a couple of years, because initially it was also the rights of men, but then Latin American delegates decided to propose, and the General Assembly of the UN accepted, to change every reference to rights of man to a reference to human rights. The French are still waiting for that. It's still droit de l'homme. Anyway, after that, the UN, we can say the UN took over, and we had initially, of course, a charter which makes many reference to the protection of human rights and fundamental freedoms, and in December 1948, the Universal Declaration of Human Rights. But the progress of the international systems for the protection of human rights will pick up speed in the regions. Initially, it was Europe, Western Europe, at the time the members of the Council of Europe, who, let's say, gave the big leap forward in establishing a binding convention which created two organs, which are the predecessors, let's say the example on which our own Inter-American system was later based, of two tiers of organs: a commission at the beginning, a tribunal, a court later. European Commission of Human Rights, now disappeared, and European Court of Human Rights. At the UN, well, in our system, in Latin, that's one of the preferred expressions of my learned friend, Margaret. She always tells us how things are in our system, which is her system, your system. So your depends on which side of the place we are. Eh? The best, okay. Thank you for that indication. If you say that in English, the best interest of the child will be best served if we do it this way. In the Inter-American system, the Commission, as I told you, was created in 1959. But we should not forget a very important instrument at the universal level, which is not usually mentioned as a human rights instrument, that it's very important, and in this place and in this area it's very important, which is the Declaration on the Granting of Independence to Colonial Countries and Peoples. Here again, being politically correct in speech, we wouldn't say granting, we would say recognition, because it led to the recognition of independence of dozens, scores of states in Africa and in the Caribbean and in other places of the world. Later on, at the American level, the Buenos Aires Amendments of 1967 to the OAS Charter led to a change in nature of the Inter-American Commission. It had first been created by a resolution of one of the organs of the OAS, and another resolution could eliminate it. Since these changes, these amendments to the OAS Charter, the Commission was made one of the principal organs of the Organization of American States, and there was also a provision that a further treaty would protect international human rights and create other institutions for that end. We should mention also that, of course, the European system developed very quickly, and at some point in time, they decided that they didn't need any longer the Commission, so they have now a two-tier level of judicial institutions, not a quasi-judicial institution as the Commission and a judicial institution as the Court, but courts of first instance and Court of Appeals. That's an adjustment to my low level. And also Africa has its own Charter of Human and People's Rights, which started having only a commission, and then it added a court. Whereas at the international level, we had since 1966, but entering into force in 1976, the two international covenants, one on economic social and cultural rights, the other one on civil and political rights, with its optional protocol, which allowed at the universal level the participation of individuals and private organizations and NGOs. Now, let's go to our own convention, the American Convention on Human Rights. It marked a very important change in the Inter-American system because it was the first binding document, a binding instrument, recognizing rights because they are not created by the legal rule, they are inherent to human personality, and that's the way they are treated. And it also established a list and a characterization of those rights, and established these organs which we are supposed to talk about right now. There are some common or similar elements between the Commission and the Court. Both of them have 7 members. Members are elected. We are elected on our personal capacities. This is not an intergovernmental organ where each government appoints its delegates. And we are supposed to have in the Commission high moral character, in the Court high moral authority. You'll say if that is true in my case later on, so you know me better. In both cases, it has to be a person, and a member of these organs has to be a person of recognized competence in the field of human rights. And in the Court, there is also a requirement that we be jurists. We are supposed to have the qualifications required for the exercise of the highest judicial functions in our own states. The Commission has, on the one hand, a dual nature, and on the other hand, dual functions. What do I mean by a dual nature? It means that there are OAS members who are not parties to the convention, to the Pact of San Jose, as we call it, to make it shorter. In that case, the Commission acts as the organ created initially in 1959 and then modified in the 1967 amendments to the Charter. If we are talking about states parties to the convention, all the full-fledged functions of the Commission may be exercised. On the other hand, we can say dual functions, because we might say there are case-related functions and non-case-related functions, meaning by case in here, the consideration of allegations of specific violations. I'll try to focus on the case-related functions of both organs. Apparently we are going to have, if time permits, some time for questions, so some things I will leave there. But we'll try to concentrate, to focus on the case-related functions of the Commission and the Court. So we can also say that the Court has case-related functions and non-case-related functions. If by that we mean contentious jurisdiction on one side and advisory, consultative jurisdiction on the other. Regarding the handling of cases, there is a fundamental difference in the access to the organs, because individuals and organizations have access to the Commission. They do not have direct access to the Court. Cases can only be referred to the Court by either the Commission or by a state. There is also a provision that states, if there is a special declaration, which very few have made and has never been used, to the best of my recollection, that states can also transmit to the Commission communications regarding alleged violations of human rights in other countries. As I said, the Commission is a quasi-judicial organ. This means that it's practically the same in many, many respects as a judicial organ, but except that it lacks teeth. They cannot bite with a binding judgment. They can only reach conclusions, make recommendations, try to find an agreed solution or compliance by the state. If they don't, they may refer, and now I think the practice is that they practically always refer cases where violations have been found and the state has not complied, refer the cases to the Inter-American Court of Human Rights. So we in the court only receive those cases which have gone initially before the Commission. The Commission has found a violation and referral to the court has been made. In both organs, we have to follow what you would call an adversary proceeding. We have parties, we have evidence, and we reach conclusions. In the court, those conclusions form the basis of a judgment, and the judgment is final, there is no appeal, and it's binding on the state's parties. The party, a state who has been a party to a case before the court, has undertaken to apply, to accept, and enforce the judgment of the Inter-American Court. The system is also completed by something that I will mention very briefly before Margaret looks at me askance again, and which is that it is not a fast system. Justice is never fast anywhere, but in the international sphere, it's very, very slow. What do we have for that? We have the institution of provisional measures, which the court may take either when it has a case before it or when the Commission, before referring a case, requests the court to take those provisional measures, which are a very, very important part of the protection of human rights and consequently a very important part of our work. Now it's the final time, and I'm about to get a reprimand. So let me finish here.
It is my pleasure now to introduce to you the next speaker. She's Arancha Villa Nueva. My pronunciation of Spanish names is atrocious, even after all these years. She forgives me, I'm sure. She's a member of the court in the capacity of an attorney. She's a Spanish attorney who couldn't resist coming to our court and working in our court. She's extremely hardworking, extremely knowledgeable, and passionately interested in the protection of human rights and in issues of the protection of women and children. She is going to speak on how to submit a petition. Thank you. Please welcome Arancha.
Thank you very much for your warm words always. I must admit that I feel a lot of pressure sitting there with all the honorable judges. I'm in charge of, and I promise I will be very, very brief, so you have time also to enjoy the topics of that are going to talk all the judges. I will talk about how to submit a petition, which I think is important for those people, especially the students, law students, who might think that in a situation of human rights violations, you should know that the system is achievable. You can go to the system. It's not something there is in Washington or in Costa Rica. Talking about the submission of a petition, we are talking about the commission because as Judge Perez already said, there are two organs and individuals can go to the system just through the commission. Only the states parties to the American Convention who have accepted the court's contentious jurisdiction and the commission may submit a case to the court. Individuals do not have direct recourse to the court. They must first submit the petition to the commission and go through the procedure that I should advise that might take some years, sometimes many years. But with patience, the case might come to the court soon. Who can submit a petition? Any individual, group of individuals, or organizations, and they must submit a petition against one or more member states of the OAS considered to have violated the human rights contained in the American Declaration, the American Convention, or any other inter-American human rights treaties. There is no possibility to file a petition against individuals, just against the states, and this is because the Commission and the court cannot determine whether an individual person is or not guilty for a human rights violation. There are some requirements to file a petition. And the first one is that the person must have exhausted the domestic judicial remedies, which means that the person must first attempt to have the domestic courts decide on the situation they are denouncing. A person has exhausted the domestic remedies when the judicial branch of the country has issued a decision of last resort. There are some exceptions to this rule, and so the Commission may analyze a petition in which domestic remedies have not been exhausted when the domestic laws do not provide due process to protect the rights. The alleged victims has not been allowed access to domestic remedies and has been kept from exhausting them, or if there is a delay in the issuance of a final decision on the case with no valid reason. There is also another requirement to file a petition, which is that the petition must be submitted within 6 months of the date of notification of the final judicial decision that exhausted the domestic remedies. And the other requirement is that the subject of the petition is not pending in another international organization. In the process of filling a petition, it's important maybe to know that there is no requirement to have representation of a lawyer. Any individual or organization on its own or in representation of the victim can file a petition. And there is the procedure before the Commission and also before the court are free of charge. So it's very simple, just through the website of the Commission it's possible to fill in a form and send it per internet. About the languages, the official languages of the Commission and the court are Spanish, English, Portuguese, and French. And generally, it's only necessary to send the petition in one of these languages used by the state. But if the Commission decides to process the petition, it should be forwarded to the state in the official language this state uses. So when a petition is not in that language, it is possible that the Commission may require the petitioner to seek the means necessary for it to be translated. The petition should include some information, like personal information of the alleged victims, the personal information of the petitioners if they are not the same, a complete, clear, and detailed description of the facts that should include how, when, and when the things occur, the violation occur, as well as the state considered responsible, and should include an indication of the state authorities considered responsible and those authorities in the state to which the person has turned to remedy the violation. If possible, it's important if the petitioner send copies of the principal complaints and motions filed in pursuit of the remedy and the domestic judicial decisions. I think pretty much this is what the requirements for the submission of a petition are. Should be sent also the copies of all the documents, not the originals, because the Commission won't give the originals back even if it doesn't admit the case. When the Commission receives the petition, then it sends a letter acknowledge receipt of it and indicating the reference number assigned. And the petitioner can send additional information after the petition itself, and all this information will be filed with the petition itself. And well, I think this is pretty much very briefly how to submit a petition before the Commission. Then the process in the Commission might last some years, and well, there is the process of admissibility, and then another process until the Commission decides whether or not the case will be brought before the court. So I think that's all. I hope it was useful.
You were very timely. Thank you, Arantxa, for that very clear talk on how to submit a petition. I think logically I should next call on Dr. Caroline Gomes to do her intervention, which is the Inter-American system, the Jamaican experience, which was missing from your program. Because this is, the Jamaicans for Justice organization is, I think, perhaps the only one that I know of which has taken petitions and we submitted reports of all kinds to the Commission. So they've interfaced with the Commission and have experience. Let me just tell you a little bit about Dr. Gomes, who, being a doctor, gave me a little bit of information about herself. She is a pediatrician by training and practices one for over 20 years in public and private practice, both in the health systems of Trinidad and Jamaica, so she's a true Caribbean citizen. In 1999, she co-founded Jamaicans for Justice and served as its first chairperson until 2002. Since then, she has stopped practicing medicine and she engages full-time in the protection of human rights as the executive director of the organization. And since the beginning of 2000, she has spearheaded their organization's work in submitting matters to the Inter-American Commission. They have appeared there several times, they've taken petitions, they've requested precautionary measures, and as I said, submitted various reports. I know that they submitted a very comprehensive report about the state of children in state care in Jamaica, which sort of opened the closed doors of what had been happening to our children. So please help me welcome Dr. Caroline Gomes.
Thank you, Madam Moderator. Distinguished panel, distinguished ladies and gentlemen, my great honor and pleasure to be here. One of the few at the head table without justice in front of my name. Never mind. Hopefully I have something that you'll be interested to hear. I must confess that the idea that an ordinary citizen of Jamaica could approach the Inter-American Commission on Human Rights or the court for any reason whatsoever was unknown to me until 2000. This was when Amnesty International approached us. We had been doing some work with them and asked us if we would like to appear with them at the commission at a hearing that they had requested. That's when I began to start to interface with the Inter-American system. In the intervening years, I've grown to know happily that the system exists, that it is accessible to every Caribbean citizen, every citizen of the Americas, and in fact what it can offer for us. As you heard earlier, there are different levels of the system. Our interface with Jamaicans for Justice has been at the level of the Commission because Jamaica has not accepted the jurisdiction of the court. But the Commission has several mechanisms through which ordinary persons can carry their concerns about potential or actual breaches of human rights to them. The mechanisms include providing reports, requesting appearances, presenting petitions, making requests for precautionary measures on behalf of persons at risk. And these are only the ones that I know about. There may well be others. For us, we have used all those outlined. And as you have heard, any citizen of the countries which belong to the OAS can submit a report to the Inter-American System on Human Rights on any actual, potential, or perceived breaches of the American Declaration of the Rights and Duties of Man. For citizens of those states which have ratified the American Convention on Human Rights, they have the right to lodge petitions with the Commission complaining of violations of the Convention. Reports can be prepared by anybody, and I promise you that's true. Our first reports to the Commission were entirely prepared by laypersons, persons with no legal training whatsoever. But we sat and set out what we thought was wrong and told the Commission about it. The reports can be submitted in many different ways. Our first report, as I said, was submitted in person at a hearing in Washington. The hearing had been requested by Amnesty International. And it was kind of intimidating, particularly as a Caribbean person, because it is mostly Spanish you hear as you walk in, and that's what you're greeted with. But people are very willing to work with you when you say, well, I'm sorry, I don't have any Spanish. And very welcoming and very helpful in directing you what to do, where to go, etc. But after that first report at the hearing in the Commission, our second report was actually presented very publicly. We were trying to make a point in Jamaica to the visiting rapporteur on the rights of the child, and we went up to her in front of the television cameras to provide her with a stakeholder report on the situation of children in the care of the state. And the Commission is receptive. Ms. Villaran took it. Clearly she knew we were trying to buy some publicity for the issue, but she took it. She read it and then she asked to meet with us, and she sat with us and explained to us what we needed to do from here based on what we'd written in order to make an efficient and effective approach to the Commission that might change the situation. Other reports have followed over the years. In each of them, we've attempted to bring to the attention of the Commission things that concerned us about what was going on in Jamaica, what was the situation of human rights in our country in different areas. We've done on children, we've done on the situation post the state of emergency last year, we've done on the what we call the pattern of impunity, where our police force has the second highest rate of fatal shootings in the world, but nobody seems to ever get convicted of it. We've also appeared at the Commission in a number of instances, sometimes to present reports, but in one particular case, to appear at the merits hearing and to discuss the issues that we had put into a petition. Requests for hearings at the Commission are made under Chapter 7, Articles 59 and 60 of the Rules of Procedure of the Commission. And that rule states that the Commission may decide to hold hearings on its own initiative or at the request of an interested party. The hearings may be for the purpose of receiving information from the parties with respect to a petition or case, as I said in Michael Gale, or to follow up recommendations, or for precautionary measures or general or particular information related to human rights in one or more member states. So you can, as an ordinary citizen of this country or any other country in the region, take a report about the situation of human rights and present it to the Commission. So we've had 7 reports over the years. As I said, pattern of impunity, another one on killing impunity. We've done reports on detention issues in the country. We've done reports on the situation of children in the care of the state twice, and then one on this situation of human rights following the state of emergency. We've had several hearings before the Commission, a merits hearing, hearings with reports. But the other mechanism that we've used extensively is a mechanism of petitions and the special version of a petition, precautionary measures. We wrote our first petition following our first appearance at the Commission, and in it we took a particular case, Michael Gale. Some of you who are Jamaican may know about it. Young man beaten to death by security forces at a barricade. Coroner's jury said manslaughter. DPP said don't have enough evidence to prosecute. And when it could go no further, we took it to the Commission. We went through all the stages. A petition has a number of stages. It must be ruled admissible, and Ms. Villanueva told you about what is needed to be admissible. But that is a ruling that the Commission makes. You put the facts down, the state answers with facts or contrary facts, and then the Commission decides. And in that Michael Gale case, I spent a little time on it because it was an important admissibility ruling. It said that you did not have to exhaust all the measures available in a state. So the government had said to us, but you didn't do a constitutional motion, and you didn't do a judicial review, and you didn't take a private prosecution. You should have done all of those things. The Commission actually ruled that, and I quote, fundamental principles governing the nature of the remedies that must be exhausted in the Inter-American system, namely those remedies that are both adequate in that they are suitable to address an infringement of legal rights, as well as effective in that it is capable of producing the results for which it is designed. It found that private prosecutions, judicial reviews, etc. were not effective to remedy the violations complained of. So if it's serious stuff, it is the duty of the state under the convention to deal with it, not the private citizen to go off and try and find a way to deal with it. The merits decision was also very strong, and it found that wrongdoing had occurred at the hands of the state, and that the state of Jamaica needed to compensate the family, fix the flaws in the system, and it made suggestions as to what could be done, and apologize publicly to the family. Since that ruling, we've taken several other petitions on similar and related issues to the Commission, and we await rulings on many of them. Precautionary measures are a special form of petition, and in that case the matter has to be serious and urgent, and there is a need to prevent irreparable harm. So if somebody is being urgently threatened, instead of going through a long process, you say to the Commission, this is very urgent. If something isn't done, somebody may die or be irreparably harmed. And in that case, they rule quickly on matters. They don't take the months and years that they can sometimes take with petitions. We've been successful in 2 precautionary measures, and we think that they were groundbreaking. More recently, Margaret said we were the only ones. We're actually not anymore. There are others who use the system, including LGBTI groups in Jamaica, who have had 2 precautionary measures granted recently because of treatment of homosexuals in Jamaica. Very quickly, outcomes. We've got that strong admissibility ruling. We've got precautionary measures that forced the state to pay attention to an issue that it was just ignoring because it wasn't comfortable. We have the strong merits decision in the Michael Gale case, which we feel has led to changes in the system of investigating police actions, state abuse by security forces, and resulted in a change, an improvement. The results, the hearings questioned the government, forced them to look at what they're doing. Now, they may decide that what they're doing is right, but it does call into question in a very vivid way their actions as it relates to children, as it relates to police, as it relates to states of emergency. Problems, it's not binding. 7 years after the Michael Gale ruling, the state has yet to issue a public apology to his mother. Something as simple as a public apology for his death. And unfortunately, we have no access to the court, which we saw working so admirably yesterday. And quite frankly, because I'm here to tell you the truth, the Commission seriously underfunded. The delays in that Commission appear almost as bad as the delays in our court systems. Can take years to get matters out of them. But it's there. It's there for us. It's there for us who are not lawyers. Clearly, if you have legal training, it helps. But it is there for those of us who feel that our governments are not doing enough on particular issues as it relates to human rights, as a place that you can go when you feel that you've been cut off locally, or that the process has ended locally, and that justice has not been served. Lots more I could tell you, but I would encourage you to know more about the system, to use the system. Thank you.
Ladies and gentlemen, moving on. Our next speaker is Judge Manuel Ventura Robles. Judge Manuel is from Costa Rica, and he has the noted experience and the honor, I think it was, of being the first Secretary of the Court. He is the repository for us of all the history of the court. Whenever we want to find out what happened in yesteryear, we ask Manuel, and he always has it at his fingertips. He also does a lot of workshops and seminars on law, teaches law, and is an avid member of the court, very passionate about his involvement in the protection of human rights. Manuel is going to speak about the remedies under the Inter-American human rights system. Please help me to welcome him.
Thank you.
Thank you, Judge Macaulay. Good morning. My subject is remedies in the Inter-American jurisprudence of the Inter-American Court of Human Rights. So let's begin.